The Hindu Succession ACT, 1956. Arrangement of sections. CHAPTERI Preliminary. Sections 1. Short title and extent. 2. Application of Act. 3. Definitions and interpretation. 4. Overriding effect of Act. CHAPTER2 Intestate Succession General. 5. Act not to apply to certain properties. 6. Devolution of interest in coparcenary property. 7. Devolution of interest in the property of a Tarwad, Tawaji, Kutumba, Kavaru or Alom. 8. General rules of succession in the case of males. 9. Order of succession among heirs in the schedule. 10. Distribution of property among heirs in Class 1 of the schedule. 11. Distribution of property among heirs in Class 2 of the schedule. 12. Order of succession among agnates and cognates. 13. Computation of degrees. 14. Property of a female Hindu to be her absolute property. 15. General rules of succession in the case of female Hindus. 16. Order of succession and manner of distribution among heirs of a female Hindu. 17. Special provisions respecting persons governed by Maramakatayam and Aliya Shantana laws. General provisions relating to succession. 18. Full blood preferred to half blood. 19. Mode of succession of two or more heirs. 20. Right of child in womb. 21. Presumption in cases of simultaneous deaths. 22. Preferential right to acquire property in certain cases. 23. Omitted. 24. Omitted. 25. Murderer disqualified. 26. Converts descendants disqualified. 27. Succession when heir disqualified. 28. Disease, defect, etc. Not to disqualify. As cheat. 29. Failure of heirs. 2. Chapter 3 Testamentary Succession. Sections 30. Testamentary Succession. Chapter IV Repeals. 31. Repealed. The Schedule. 3. The Hindu Succession ACT, 1956 ACT No. 30 of 19,561. The 17th of June 1956. An Act to amend and codify the law relating to intestate succession among Hindus. Be it enacted by Parliament in the 7th year of the Republic of India as follows. Chapter I. Preliminary. 1. Short title and extent. 1. This Act may be called the Hindu Succession Act, 1956. 2. It extends to the whole of India except the state of Jammu and Kashmir. 2. Application of Act. 1. This Act applies to any person who is a Hindu by religion in any of its forms or developments, including a Virashaiva, a Lingayat or a follower of the Brahmo, Prarthana or Arya Samaj. B. To any person who is a Buddhist, Jaina or Sikh by religion, and C. To any other person who is not a Muslim, Christian, Parsi or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein if this Act had not been passed. Explanation. The following persons are Hindus, Buddhists, Jainas or Sikhs by religion, as the case may be, any child, legitimate or illegitimate, both of whose parents are Hindus, Buddhists, Jainas or Sikhs by religion. B. Any child, legitimate or illegitimate, one of whose parents is a Hindu, Buddhist, Jaina or Sikh by religion and who is brought up as a member of the tribe, community, group or family to which such parent belongs or belonged. C. Any person who is a convert or reconvert to the Hindu, Buddhist, Jaina or Sikh religion. 2. Notwithstanding anything contained in subsection 1, nothing contained in this Act shall apply to the members of any scheduled tribe within the meaning of Clause 25 of Article 366 of the Constitution unless the central government, by notification in the Official Gazette, otherwise directs. 3. The expression Hindu in any portion of this Act shall be construed as if it included a person who, though not a Hindu by religion, is, nevertheless, a person to whom this Act applies by virtue of the provisions contained in this section. 3. Definitions and interpretation. 1. In this Act, unless the context otherwise requires, a agnate, one person is said to be an agnate of another if the two are related by blood or adoption wholly through males. B. Aliyah law means the system of law applicable to persons who, if this Act had not been passed, would have been governed by the Madras Aliyah Act, 1949, Madras Act 9 of 1949, or by the customary Aliyah law with respect to the matters for which provision is made in this Act. C. Cognate, one person is said to be a cognate of another if the two are related by blood or adoption but not wholly through males. 1. The Act has been extended to Dadra and Nagar Haveli by Reg. 6 of 1963, S. 2 in first schedule and to Pondicherry by Reg. 7 of 1963, S. 3 in first schedule. 4. D. The expressions, custom, and usage, signify any rule which, having been continuously and uniformly observed for a long time, has obtained the force of law among Hindus in any local area, tribe, community, group or family, provided that the rule is certain and not unreasonable or opposed to public policy, and provided further that in the case of a rule applicable only to a family it has not been discontinued by the family. A. Full blood, half blood, and uterine blood. I. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife, and by half blood when they are descended from a common ancestor but by different wives. E. Two persons are said to be related to each other by uterine blood when they are descended from a common ancestress but by different husbands. Explanation. In this clause, ancestor includes the father and ancestress, the mother. F. Heir means any person, male or female, who is entitled to succeed to the property of an intestate under this Act. G. Intestate, a person is deemed to die intestate in respect of property of which he or she has not made a testamentary disposition capable of taking effect. H. Maramakatayam law means the system of law applicable to persons, who, if this Act had not been passed, would have been governed by the Madras Maramakatayam Act, 1932, Madras Act 22 of 1933. The Travancore Nair Act, 2 of 1100 K. The Travancore Ezhava Act, 3 of 1100 K. The Travancore Nanjinad Vela Act, 6 of 1101 K. The Travancore Kshatriya Act, 7 of 1108 K. The Travancore Krishnamvaka Maramakathay Act, 7 of 1115 K. The Kochi Maramakatayam Act, 33 of 1113 K. Or the Kochi Nair Act, 29 of 1113 K. With respect to the matters for which provision is made in this Act. Or, B. Who belong to any community, the members of which are largely domiciled in the state of Travancore Kochi or Madras 1, as it existed immediately before the 1st of November 1956, and who, if this Act had not been passed, would have been governed with respect to the matters for which provision is made in this Act by any system of inheritance in which descent is traced through the female line. But does not include the Aliyah law. I. Nambudri law means the system of law applicable to persons who, if this Act had not been passed, would have been governed by the Madras Nambudri Act, 1932 Madras Act, 21 of 1933. The Kochi Nambudri Act, 17 of 111 K. or the Travancore Malala Brahman Act, 3 of 1106 K. With respect to the matters for which provision is made in this Act. J. Related, means related by legitimate kinship, provided that illegitimate children shall be deemed to be related to their mother and to one another, and their legitimate descendants shall be deemed to be related to them and to one another. And any word expressing relationship or denoting a relative shall be construed accordingly. 2. In this Act, unless the context otherwise requires, words importing the masculine gender shall not be taken to include females. 4. Overriding effect of Act. 1. Save as otherwise expressly provided in this Act, any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of this Act shall cease to have effect with respect to any matter for which provision is made in this Act. 1. Ins. By the adaptation of laws, No. 3, Order, 1956. 5. B. Any other law in force immediately before the commencement of this Act shall cease to apply to Hindus in so far as it is inconsistent with any of the provisions contained in this Act. 1. Chapter 2. Intestate succession. General. 5. Act not to apply to certain properties. This Act shall not apply to I. Any property succession to which is regulated by the Indian Succession Act, 1925, 39 of 1925, by reason of the provisions contained in Section 21 of the Special Marriage Act, 1954, 43 of 1954. E. Any estate which descends to a single heir by the terms of any covenant or agreement entered into by the ruler of any Indian state with the Government of India or by the terms of any enactment passed before the commencement of this Act. E. The Valiamathampuram Kovilagam estate and the Palace Fund administered by the Palace Administration Board by reason of the powers conferred by Proclamation, IX of 1124, dated the 29th of June 1949, promulgated by the Maharaja of Kochi. 2. 6. Devolution of interest in compulsory property. 1. On and from the commencement of the Hindu Succession Amendment Act, 2005, 39 of 2005, in a joint Hindu family governed by the Mitikshara law, the daughter of a Kopasena shall, by birth become a Kopasena in her own right the same manner as the son. B. Have the same rights in the Kopasenary property as she would have had if she had been a son. C. Be subject to the same liabilities in respect of the said Kopasenary property as that of a son, and any reference to a Hindu Mitikshara Kopasena shall be deemed to include a reference to a daughter of a Kopasena, provided that nothing contained in the subsection shall affect or invalidate any disposition or alienation including any partition or testamentary disposition of property which had taken place before the 20th day of December, 2004. 2. Any property to which a female Hindu becomes entitled by virtue of subsection 1, shall be held by her with the incidence of Kopasenary ownership and shall be regarded, notwithstanding anything contained in this Act or any other law for the time being in force, as property capable of being disposed of by her by testamentary disposition. 3. Where a Hindu dies after the commencement of the Hindu Succession Amendment Act, 2005, 39 of 2005, his interest in the property of a joint Hindu family governed by the Mitakshara law, shall devolve by testamentary or intestate succession, as the case may be, under this Act and not by survivorship, and the Kopasenary property shall be deemed to have been divided as if a partition had taken place and, the daughter is allotted the same share as is allotted to a son. B. The share of the predeceased son or a predeceased daughter, as they would have got had they been alive at the time of partition, shall be allotted to the surviving child of such predeceased son or of such predeceased daughter. And, C. The share of the predeceased child of a predeceased son or of a predeceased daughter, as such child would have got had he or she been alive at the time of the partition, shall be allotted to the child of such predeceased child of the predeceased son or a predeceased daughter, as the case may be. 1. Omitted by Act 39 of 2005, S. 2. W. A. F. The 9th of September 2005. 2. Subs. By S. 3. Ibad. For Section 6, W. A. F. The 9th of September 2005. 6. Explanation. For the purposes of this subsection, the interest of a Hindu Mitakshara Kopasna shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before his death, irrespective of whether he was entitled to claim partition or not. 4. After the commencement of the Hindu Succession Amendment Act 2005, 39 of 2005, no court shall recognize any right to proceed against a son, grandson or great-grandson for the recovery of any debt due from his father, grandfather or great-grandfather solely on the ground of the pious obligation under the Hindu law of such son, grandson or great-grandson to discharge any such debt, provided that in the case of any debt contracted before the commencement of the Hindu Succession Amendment Act 2005, 39 of 2005, nothing contained in this subsection shall affect a. The right of any creditor to proceed against the son, grandson or great-grandson, as the case may be. Or b. Any alienation made in respect of or in satisfaction of any such debt, and any such right or alienation shall be enforceable under the rule of pious obligation in the same manner and to the same extent as it would have been enforceable as if the Hindu Succession Amendment Act 2005, 39 of 2005, had not been enacted. Explanation. For the purposes of clause a, the expression son, grandson, or great-grandson shall be deemed to refer to the son, grandson or great-grandson, as the case may be, who was born or adopted prior to the commencement of the Hindu Succession Amendment Act 2005, 39 of 2005. 5. Nothing contained in this section shall apply to a partition, which has been effected before the 20th day of December, 2004. Explanation. For the purposes of this section, partition means any partition made by execution of a deed of partition duly registered under the Registration Act, 1908, 16 of 1908, or partition effected by a decree of a court. 7. Devolution of interest in the property of a Tarwad, Tawaji, Kutumba, Kavaru or Alom. 1. When a Hindu to whom the Maramakatayam or Nambudri law would have applied if this act had not been passed dies after the commencement of this act, having at the time of his or her death an interest in the property of a Tarwad, Tawaji or Alom, as the case may be, his or her interest in the property shall devolve by testamentary or intestate succession, as the case may be, under this act and not according to the Maramakatayam or Nambudri law. Explanation. For the purposes of this subsection, the interest of a Hindu in the property of a Tarwad, Tawaji or Alom shall be deemed to be the share in the property of the Tarwad, Tawaji or Alom, as the case may be, that would have fallen to him or her if a partition of that property per capita had been made immediately before his or her death among all the members of the Tarwad, Tawaji or Alom, as the case may be, then living, whether he or she was entitled to claim such partition or not under the Maramakatayam or Nambudri law applicable to him or her, and such share shall be deemed to have been allotted to him or her absolutely. 2. When a Hindu to whom the Aliyashantana law would have applied if this act had not been passed dies after the commencement of this act, having at the time of his or her death an undivided interest in the property of a Kutumba or Kavaru, as the case may be, his or her interest in the property shall devolve by testamentary or intestate succession, as the case may be, under this act and not according to the Aliyashantana law. Explanation. For the purposes of this subsection, the interest of a Hindu in the property of a Kutumba or Kavaru shall be deemed to be the share in the property of the Kutumba or Kavaru, as the case may be, that would have fallen to him or her if a partition of that property per capita had been made immediately before his or her death among all the members of the Kutumba or Kavaru, as the case may be, then living, whether he or she was entitled to claim such partition or not under the Aliyashantana law, and such share shall be deemed to have been allotted to him or her absolutely. 7. 3. Notwithstanding anything contained in subsection 1, when a Sthanamdar dies after the commencement of this act, the Sthanam property held by him shall devolve upon the members of the family to which the Sthanamdar belonged and the heirs of the Sthanamdar as if the Sthanam property had been divided per capita immediately before the death of the Sthanamdar among himself and all the members of his family then living, and the shares falling to the members of his family and the heirs of the Sthanamdar shall be held by them as their separate property. Explanation. For the purposes of this subsection, the family of a Sthanamdar shall include every branch of that family, whether divided or undivided, the male members of which would have been entitled by any custom or usage to succeed to the position of Sthanamdar if this act had not been passed. 8. General rules of succession in the case of males. The property of a male Hindu dying intestate shall devolve according to the provisions of this chapter, firstly, upon the heirs, being the relatives specified in Class 1 of the schedule. B. Secondly, if there is no heir of Class 1, then upon the heirs, being the relatives specified in Class 2 of the schedule. C. Thirdly, if there is no heir of any of the two classes, then upon the agnates of the deceased. And D. Lastly, if there is no agnate, then upon the cognates of the deceased. 9. Order of succession among heirs in the schedule. Among the heirs specified in the schedule, those in Class 1 shall take simultaneously and to the exclusion of all other heirs. Those in the first entry in Class 2 shall be preferred to those in the second entry. Those in the second entry shall be preferred to those in the third entry. And so on in succession. 10. Distribution of property among heirs in Class 1 of the schedule. The property of an intestate shall be divided among the heirs in Class 1 of the schedule in accordance with the following rules. Rule 1. The intestate's widow, or if there are more widows than one, all the widows together, shall take one share. Rule 2. The surviving sons and daughters and the mother of the intestate shall each take one share. Rule 3. The heirs in the branch of each predeceased son or each predeceased daughter of the intestate shall take between them one share. Rule 4. The distribution of the share referred to in Rule 3. I. Among the heirs in the branch of the predeceased son shall be so made that his widow, or widows together, and the surviving sons and daughters get equal portions. And the branch of his predeceased sons gets the same portion. E. Among the heirs in the branch of the predeceased daughter shall be so made that the surviving sons and daughters get equal portions. 11. Distribution of property among heirs in Class 2 of the schedule. The property of an intestate shall be divided between the heirs specified in any one entry in Class 2 of the schedule so that they share equally. 12. Order of succession among agnates and cognates. The order of succession among agnates or cognates, as the case may be, shall be determined in accordance with the rules of preference laid down hereunder. Rule 1. Of two heirs, the one who has fewer or no degrees of ascent is preferred. Rule 2. Where the number of degrees of ascent is the same or none, that heir is preferred who has fewer or no degrees of descent. Rule 3. Where neither heir is entitled to be preferred to the other under Rule 1 or Rule 2, they take simultaneously. 8. 13. Computation of degrees. 1. For the purposes of determining the order of succession among agnates or cognates, relationship shall be reckoned from the intestate to the heir in terms of degrees of ascent or degrees of descent or both, as the case may be. 2. Degrees of ascent and degrees of descent shall be computed inclusive of the intestate. 3. Every generation constitutes a degree either ascending or descending. 14. Property of a female Hindu to be her absolute property. 1. Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited owner. Explanation. In this subsection, property includes both movable and immovable property acquired by a female Hindu by inheritance or devise, or at a partition, or in lieu of maintenance or arrears of maintenance, or by gift from any person, whether a relative or not, before, at or after her marriage, or by her own skill or exertion, or by purchase or by prescription, or in any other manner whatsoever, and also any such property held by her as stridhana immediately before the commencement of this act. 2. Nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under a decree or order of a civil court or under an award where the terms of the gift, will or other instrument or the decree, order or award prescribe a restricted estate in such property. 15. General rules of succession in the case of female Hindus. 1. The property of a female Hindu dying intestate shall devolve according to the rules set out in section 16, firstly, upon the sons and daughters, including the children of any predeceased son or daughter, and the husband. B. Secondly, upon the heirs of the husband. C. Thirdly, upon the mother and father. D. Fourthly, upon the heirs of the father. And A. Lastly, upon the heirs of the mother. 2. Notwithstanding anything contained in subsection 1, any property inherited by a female Hindu from her father or mother shall devolve, in the absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, not upon the other heirs referred in subsection 1, in the order specified therein, but upon the heirs of the father. And B. Any property inherited by a female Hindu from her husband or from her father-in-law shall devolve, in the absence of any son or daughter of the deceased, including the children of any predeceased son or daughter, not upon the other heirs referred to in subsection 1, in the order specified therein, but upon the heirs of the husband. 16. Order of succession and manner of distribution among heirs of a female Hindu. The order of succession among the heirs referred to in section 15 shall be, and the distribution of the intestate's property among those heirs shall take place according to the following rules, namely, Rule 1. Among the heirs specified in subsection 1 of section 15, those in one entry shall be preferred to those in any succeeding entry, and those included in the same entry shall take simultaneously. Rule 2. If any son or daughter of the intestate had predeceased the intestate leaving his or her own children alive at the time of the intestate's death, the children of such son or daughter shall take between them the share which such son or daughter would have taken if living at the intestate's death. Rule 3. The devolution of the property of the intestate on the heirs referred to in clauses B, D, and A of subsection 1, and in subsection 2 of section 15 shall be in the same order and according to the same rules as would have applied if the property had been the father's or the mother's or the husband's as 9. The case may be, and such person had died intestate in respect thereof immediately after the intestate's death. 17. Special provisions respecting persons governed by Maramakatayam and Atiyasantana laws. The provisions of sections 8, 10, 15 and 23 shall have effect in relation to persons who would have been governed by the Maramakatayam law or Aliyashantana law if this act had not been passed as if I. For subclauses C and D of section 8, the following had been substituted, namely, C. Thirdly, if there is no heir of any of the two classes, then upon his relatives, whether agnates or cognates. E. For clauses A to A of subsection 1 of section 15, the following had been substituted, namely, A. Firstly, upon the sons and daughters, including the children of any predeceased son or daughter, and the mother. B. Secondly, upon the father and the husband. C. Thirdly, upon the heirs of the mother. D. Fourthly, upon the heirs of the father. And A. Lastly, upon the heirs of the husband. E. Clause A of subsection 2 of section 15 had been omitted. IV. Section 23 had been omitted. General provisions relating to succession. 18. Full blood preferred to half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood, if the nature of the relationship is the same in every other respect. 19. Mode of succession of two or more heirs. If two or more heirs succeed together to the property of an intestate, they shall take the property, save as otherwise expressly provided in this Act, per capita and not per stirpes. And B. As tenants in common and not as joint tenants. 20. Right of child in womb. A child who was in the womb at the time of the death of an intestate and who is subsequently born alive shall have the same right to inherit to the intestate as if he or she had been born before the death of the intestate, and the inheritance shall be deemed to vest in such a case with effect from the date of the death of the intestate. 21. Presumption in cases of simultaneous deaths. Where two persons have died in circumstances rendering it uncertain whether either of them, and if so which, survived the other, then, for all purposes affecting succession to property, it shall be presumed, until the contrary is proved, that the younger survived the elder. 22. Preferential right to acquire property in certain cases. 1. Where, after the commencement of this Act, an interest in any immovable property of an intestate, or in any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in Class 1 of the schedule, and any one of such heirs proposes to transfer his or her interest in the property or business, the other heirs shall have a preferential right to acquire the interest proposed to be transferred. 2. The consideration for which any interest in the property of the deceased may be transferred under this section shall, in the absence of any agreement between the parties, be determined by the court on application being made to it in this behalf, and if any person proposing to acquire the interest is not willing to acquire it for the consideration so determined, such person shall be liable to pay all costs of or incident to the application. 10. 3. If there are two or more heirs specified in Class 1 of the schedule proposing to acquire any interest under this section, that heir who offers the highest consideration for the transfer shall be preferred. Explanation. In this section, court means the court within the limits of whose jurisdiction the immovable property is situate or the business is carried on, and includes any other court which the state government may, by notification in the official gazette, specify in this behalf. 23. Special provision respecting dwelling houses. Omitted by the Hindu Succession Amendment Act 2005, 39 of 2005, S. 4, W, A, F, the 9th of September 2005. 24. Certain widows remarrying may not inherit as widows. Omitted by S. 5, Ibid. W, A, F, the 9th of September 2005. 25. Murderer disqualified. A person who commits murder or abets the commission of murder shall be disqualified from inheriting the property of the person murdered, or any other property in furtherance of the succession to which he or she committed or abetted the commission of the murder. 26. Converts descendants disqualified. Where, before or after the commencement of this Act, a Hindu has ceased or ceases to be a Hindu by conversion to another religion, children born to him or her after such conversion and their descendants shall be disqualified from inheriting the property of any of their Hindu relatives, unless such children or descendants are Hindus at the time when the succession opens. 27. Succession when heir disqualified. If any person is disqualified from inheriting any property under this Act, it shall devolve as if such person had died before the intestate. 28. Disease, defect, etc. Not to disqualify. No person shall be disqualified from succeeding to any property on the ground of any disease, defect or deformity, or save as provided in this Act, on any other ground whatsoever. Escheat. 29. Failure of heirs. If an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of this Act, such property shall devolve on the government. And the government shall take the property subject to all the obligations and liabilities to which an heir would have been subject. Chapter 3. Testamentary Succession. 30. Testamentary Succession. -1****. Any Hindu may dispose of by will or other testamentary disposition any property, which is capable of being so too, disposed of by him or by her, in accordance with the provisions of the Indian Succession Act, 1925, 39 of 1925, or any other law for the time being in force and applicable to Hindus. Explanation. The interest of a male Hindu in a Mitakshara Kopasanari property or the interest of a member of a Tarwad, Tawaji, Alom, Kutumba or Kavaru in the property of the Tarwad, Tawaji, Alom, Kutumba or Kavaru shall, notwithstanding anything contained in this Act or in any other law for the time being in force, be deemed to be property capable of being disposed of by him or by her within the meaning of this 3, section 4. 1.